procedure. I'm sure everybody here understands how we operate, but I always feel better if I mention it before we start. First of all, each side gets 15 minutes to make its oral argument. If you are the appellant and you wish to reserve any rebuttal time, you may do that by, after you've come up and introduced yourself, before you begin your argument, requesting that from the court. You may reserve up to 5 minutes of oral argument. Obviously, the appellee gets no rebuttal time. In order to aid you, we have a lighting system on the podium. There are 3 lights on the podium. Once you begin your argument, a green light will come on. So long as the light's green, you've got plenty of time to make your argument. Once the light turns yellow, it means you're running out of time. And once the light turns red, you are out of time, and we ask that you please respect those time constraints. One very important thing I want to make everyone mindful of. These arguments are being live streamed. So think about what you're going to say before you say it, because we unfortunately have had instances in the past when we've had advocates who've said some things that they wish they could pull back. So we can't do that. Once you've said it, it's out there, and that's the best we can do. So I just want to make you aware of that. Your panel for this afternoon consists of Judge Karma McGee from Savannah, Judge Valerie Smith from Memphis, and I'm Steve Stafford from Dyersburg. Ms. Ashley, anything we need to take up before you call the first case? No, Your Honor. You may call the first case, please.
Authorized Equipment, Inc. et al. versus EquipmentShare.com, Inc. et al.
All right, we'll hear from the appellant. Now I'm confused.
May it please the court, my name is Gino Bolso here on behalf of the appellant. With the court's permission, I'll reserve 3 minutes for my time of rebuttal.
All right, sir. You may proceed.
Thank you, Your Honor. This case comes to the court on an appeal of a directed verdict motion that was granted by the trial court at the close of the plaintiff's proof when this matter was tried just about a year ago on November 6 of 2024. The basis for the trial court's directed verdict was an alleged failure of the proof to establish damages under any one of the 3 theories that plaintiff had set out in its complaint: breach of contract, intentional interference with a business relationship, or promissory fraud. In issuing that directed verdict ruling, unfortunately, the trial court simply ignored the evidence that was in the record that establishes damages for each one of those 3 counts. And that's where I'd like to begin, just focusing the court on what evidence was in the record at the time that the trial court granted this directed verdict motion on the afternoon of November 6 of 2024. Principally, the evidence of damages came in through a witness named Chris Stevens, a longtime employee of Authorized Equipment who was an expert in heavy equipment, the purchase, the sale, the value, the maintenance of heavy equipment. And Mr. Stevens testified to 3 things in particular with regard to damages. One, he testified that the value, the orderly liquidation value of this company's equipment was $6,424,000. And that was a calculation that he had just recently made in contemplation of this transaction with EquipmentShare. And that valuation is set out in Exhibit 12 of the trial exhibits. And Mr. Stevens also established that the equipment was sold at a forced liquidation sale on December 7 of 2019 for a net of $4,300,000, which left damages of $2,124,000, because as the proof had established through Mr. Stevens' testimony, through Mr. Mickey Mitchell's testimony through the documentary evidence, the plaintiff had relied upon certain commitments, promises that Equipment Share, through its representative, John Miller, had made, that it would purchase Equipment Share stock from Mr. Mitchell for a price of $4.3 million. That was the understanding that Mr. Mitchell had, and that's the understanding that he relied on all the way through the transaction until October of 2019, when he received an email from Mr. Miller essentially saying that the Equipment Share was not going to pay more than about $2 or $2.25 million for the equipment. And because of the change of position of Equipment Share, it had already taken too long for Mr. Mitchell and his company to find another place of business, because under the post-occupancy closing agreement that the parties had signed, Equipment Share was going to be taking over the property in November of 2019. And as Mr. Mitchell testified on page 167 of volume 23 of the transcript, it was too late by then for them to go ahead and find another building and continue to do business. And so this forced liquidation sale came about. And so that was the first element of damages that the record clearly established, the loss of value in the equipment in the amount of $2,124,000. The second item of damages also came from Mr. Stevens. Mr. Stevens testified that when Equipment Share's representatives came up to Laverne from Texas, they requested that he pull 40-ton excavator pieces of equipment from customers to whom Authorized Equipment had leased those. And so Mr. Stevens pulled those in reliance on these promises that Equipment Share was going to close this transaction for a purchase of the stock at $4.3 million. And when Mr. Stevens brought those pieces of equipment in, those 10 40-ton excavators, he said that they spent approximately $200,000 refurbishing them so that they could be sent down with the Equipment Share representatives to Dallas, Texas, for their use somewhere in the Southwest. He also...
I'm having difficulty understanding that theory, because it seems like, and perhaps it's not a damage issue, maybe it's another issue that I'm having difficulty following here, is they didn't, as I understand it, they didn't tell your client's representative to do this. They requested that he do this, and he could have said no. Is that accurate? Am I misunderstanding that? And I may be conflating damages and causation here.
Yeah, what you're saying, Judge Stafford, is true. Yeah, obviously, at the time that these transactions occurred, Authorized Equipment was still owned and controlled by Mickey Mitchell. So neither Mr. Mitchell nor Mr. Stevens had to do anything that anyone from Equipment Share suggested or requested. But it does show that there was reliance on the promise to go ahead and follow through and close a purchase, which is the source of the causation for the damages. And the court is also correct, Judge Stafford, that when you look at the trial court's ruling on volume 24 of the transcript, the basis for the directed verdict was simply lack of evidence of damages. There was no other basis. For example, lack of causation, lack of proof of some element or something of that nature. And the issue of whether or not Authorized Equipment had to actually call the equipment in was not a basis for the directed verdict ruling. None of that discussion appears. It was just that there was an alleged lack of proof by the plaintiff to show any damages from the alleged promissory fraud, intentional interference, or breach of contract. But what Mr. Stevens said very clearly was that the company spent approximately $200,000 refurbishing these trucks that it was not able to recoup in the course of that forced liquidation sale on December of 2019. So that was also damages that was recoverable. And one could quibble about whether or not there was in fact, a promise made, whether there was interference, whether there was a breach of contract. But when you just look at damages, which was the basis for the court's ruling, there's no question that Mr. Stevens very competently testified that that Authorized Equipment had spent approximately $200,000 refurbishing these 10 40-ton excavators, all of which was a loss because Equipment Share did not close the deal, and the equipment was sold at a forced sale on December 7. And then equally important, the third item, was that there was a loss of rental income because Mr. Stevens brought in these 10 excavators. When you look at his testimony, he testified very clearly that these 40-ton units rent for $11,500 a month, and that Authorized Equipment replaced those pieces of equipment with either 25 or 35-ton units, which rented at lower rates. And when you total the actual damages caused by lost rental income, it's approximately $39,000. So once again, whether one credits the validity of liability, the fact is that Mr. Stevens testified that there was a loss of income as a result of this request that they relied on and brought the equipment in to the extent of $39,000. So those are three solid pieces of evidence of damages that the trial court did not even discuss in her ruling, her directed verdict ruling at the close of plaintiff's case. And there's a fourth issue, which is the exclusion of Steve Nestor, who testified as an expert witness. The trial court excluded his testimony on grounds that simply do not comport with the law. When you look at page 418 of volume 24 of the trial transcript, it's clear that the trial court excluded Mr. Nestor as a qualified expert for the sole reason that he did not hold a certified valuation analyst certification. That's exactly what the transcript says. And respectfully, that's not a basis on which, under Tennessee law, an expert can be excluded. And we've got the McDaniel test, which goes into numerous factors. And it's very clear that there is no litmus test for determining who may testify as an expert. When we look at Rule 702 of our Rules of Evidence, it's clear that anyone who's qualified by knowledge, skill, experience, training, or education can be qualified to be an expert witness. But here, the trial court simply excluded Mr. Nestor from testifying about business valuation because of this alleged lack of a certification. That was error. And as a result of that error, the trial court excluded Mr. Nestor from testifying to the lost goodwill, which was another item of damages in excess of $2 million.
Was he voir dire as to his qualifications?
Yes, Your Honor, he was.
Okay. And what was his qualification as far as being able to testify as to the goodwill?
They were extensive. I mean, he is a certified public accountant. He has been licensed in Tennessee as a certified public accountant for 40 years. He's someone who has testified as an expert previously on business valuation issues. He's someone who has actually valued businesses. He's taken continuing legal education in business valuation courses, and he was intimately familiar with the assets of this company and the history, the financial history of this company, because he had been the accountant for this company for a period of over 20 years. And on those qualifications, he should have been allowed to testify. Frankly, Your Honor, when you look at the transcript, although the defendant objected on summary judgment to Mr. Nestor's qualifications, when he was called to testify, defense counsel simply stood up and advised the court that it wanted to preserve its objections by objecting to his qualifications. And that was going to be it, and we were going to move on with the trial. It was the court that said, well, let's go ahead and stop, sent the jury out, and then we had this discussion. And that is also an issue that we've said was erroneous, Your Honor. Thank you.
Thank you. You've got your rebuttal time. We'll hear from the appellee.
Thank you, Your Honors. Jason Callan here on behalf of the Applee Defendants, EquipmentShare.com, and Jonathan Miller. Your Honors, throughout this case, plaintiffs have tried to tell a very simple story, and that is that EquipmentShare allegedly lied in saying that it would purchase Authorized Equipment's business, and through this lie, EquipmentShare destroyed Authorized Equipment's business, causing a $5 million loss. Now, to prove this story, the plaintiffs needed to come forward at trial with evidence of a breach of a duty and a loss caused by the breach. In this case, the plaintiff said that the lie to purchase the business was the breach of the duty, and the destruction of the business with a loss of $5 million was the loss caused by the breach. But at the trial, the plaintiffs could not prove the story. They couldn't connect the dots between the breach and the damages. And this is because there was no material evidence sufficient to show a lie or damages caused by the lie. Now, as Mr. Bolso has been discussing, the trial court entered a directed verdict based on the failure of proof as to damages. And the trial court's reasoning in that regard was correct, but this court need not accept the trial court's reasoning because her decision was equally correct based on a failure of proof as to liability. And so I'd like to cover those two issues, both the failure of proof as to damages and also the failure of proof as to liability.
Did the trial court rule on the liability issue?
That we argued the liability issue, and the trial court grounded her decision solely on the failure of proof as to damages. But that can provide, under well-settled Tennessee law, an alternative basis for affirming the trial court's granting of a directed verdict. Now, Mr. Bolso has talked about these various elements of damages, including the forced liquidation sale and these trucks, and I just want to briefly address those. First, with respect to the forced liquidation of this equipment, that was never offered either in the discovery responses, at depositions, or at trial as a separate item of damages. Instead, that was a component of Mr. Nestor's, the plaintiff's accountant's, calculation of the destruction of the business, the sale of this equipment at a value less than what Authorized Equipment said the equipment was worth. So that was never a separate item of damages. The testimony as to the trucks regarding the rental amount and the work was done, I encourage the court to look at the testimony of Mr. Stevens on these points. It's in the trial record 24, begins on page 3381. Mr. Stevens never quantified the amount of time that these trucks were supposedly taken out of service, so the rental amount is irrelevant because you can't figure out what to multiply that. And also with respect to the replacement of tires and repairs, he never quantified that in any sort of precise amount. He didn't say $200,000. He said he thought it was around a couple $100,000, but he wasn't sure. And the reason that testimony, Your Honor, is so vague is because that was never the plaintiff's damages theory. Their damages theory was that their business had been destroyed, and they called on Mr. Nestor to calculate those damages. And he calculated those damages by performing his own valuation of the company. And plaintiffs have kind of tried to run away from that, now up on appeal. But during voir dire, Mr. Nestor admitted that his calculations were grounded in his valuation of Authorized Equipment. He valued Authorized Equipment on the one hand, looking at its goodwill and also looking at its fixed assets, added those together, came up with a number that was around $8 million, and then he compared that to what he says Mr. Mitchell got when he sold his equipment at an auction, which was around a loss of north of $1 million due to some tax consequences and also due to a loan that was secured by that equipment.
Did he explain how he came up with his value?
Yes, he did, Your Honor. So he came up with his value by taking previous year's EBITDA that Authorized Equipment had earned. Then he got an EBITDA multiplier by looking at what was kind of typical values for equipment rental business, multiplied that out, That's how he got the goodwill. Then he added that goodwill value to the fixed assets value of authorized equipment. So that's how he got the $8 million number. But it's very important, Your Honor, to know that methodology, his methodology, did not comply with his own professional standards. So Mr. Nestor is a member.
Explain that a little bit.
Yes. So Mr. Nestor is a member of the American Institute of Certified Public Accountants. Okay? As Mr. Bolso mentioned, he's a CPA, and he's a member of this American Institute. And that institute establishes certifications for valuators to adhere to get the certification. And it also provides standards for valuations. Okay? Mr. Nestor did not have the certification. And if your court was interested in what his qualifications were here, it's not just that he didn't have any certifications to perform evaluation. His only training were a few continuing education courses that he took a number of years ago. He'd performed 2 to 4 informal valuations and 2 to 4 what he called formal valuations a number of years ago. So that's his training. Okay, so now to get to your question, Judge Stafford, about the specific standards and methodology. The American Institute says that in performing a formal valuation, valuators are to employ 3 separate methodologies. There's an income-based approach that's looking at the income that's earned by the company. Then there is an approach where you're looking at the assets of the company. And then there's a third approach that's looking at the market value, what kind of a comparable sales analysis that a real estate valuator might do. And evaluators, appraisers are supposed to use all 3 methodologies. They'd use all 3, and then from those 3, they derive a single number. And that's insisted upon in those standards. Now, there is an exception where you don't have to go through all those 3 standards. And that's for what's called, and Mr. Nestor acknowledged this, an informal valuation. And informal valuations are just supposed to be done for the client of the appraiser, okay? Just for the client, not for public consumption.
When you say supposed to according to what?
According to the standards, the American Institute standards, they're called the Statement of Standards for Valuation Services. These are the professional standards that appraisers are supposed to follow when they're performing appraisals of businesses. They're supposed to follow all 3.
And this is just according to that group?
According to that group. And there is no authority, Your Honors, that have accepted in Tennessee an expert performing an appraisal of a business doing the methodology that Mr. Nestor did here. It's never been accepted. The 2 cases that the plaintiffs pointed to in this instance, the appraisers were going through the same methodologies that you see in these standards. They were going through all 3. So this had never been accepted before, this methodology. And it's acknowledged by the standards that this is not what you do if you're going to testify in court as an expert. There's no, and in the McDaniels test, it's true that the McDaniels test doesn't necessarily require that there be general acceptance of the expert's methodology, but the McDaniels test clearly requires that if you don't have general acceptance, you have to have other indicia of reliability. And there simply was no such indicia of reliability here. So but put Mr. Nestor aside, as we contend he was properly excluded based on lack of qualifications and an improper methodology. You don't even need to accept that, Your Honors, to affirm that the trial court was correct in granting the directed verdict. First, you look at the breach of contract claim, Your Honors. The damages theory for the breach of contract claim really had nothing to do with Mr. Nestor. Okay. The plaintiff acknowledged on the witness stand that he was not relying upon Mr. Nestor's $5 million number for his breach of contract claim. And that's because his breach of contract claim simply was that Equipment Share had parked its equipment in the wrong spot and had put up signs. That was his damages theory. The plaintiffs never connected any damages to the misplaced equipment or the putting up of signs. They acknowledged that throughout that period of time, they continued to do business. They could not identify a single lost sale or a single lost customer, not a one. So the directed verdict on the breach of contract claim was perfectly proper, whether you credit the exclusion of Mr. Nestor or not. As to the other two claims, which were really the primary claims, Your Honors, in this case, the tortious interference claim and the promissory fraud, those also fail, Your Honor, for a lack of proof. There was no material evidence on critical elements of both of those claims. So tortious interference claim, I know Your Honors are very familiar with the TrawMed case. One of the elements of the TrawMed case is that the plaintiffs had to put forward and identify a specific set of customers or identifiable class of prospective customers. In this case, the plaintiffs never did that. Instead, the only evidence that they put forward of customers interfered with was a contact list dating back to the 1990s of every person and entity that they had ever rented equipment to. And they acknowledged, Your Honor, they admitted on the stand at trial that they could not say who of any of these individuals they were still doing or still had been doing business with, and they acknowledged that some they had stopped doing business with long before entirely. So that is insufficient proof on that critical element. The other element that's required under the TrawMed case is either improper motive or improper means. In improper means, as the court knows, you have to show that the defendant's prominent purpose in the actions at issue was to destroy the plaintiff's business. There was no proof whatsoever that was offered that the predominant purpose of the defendants here was to destroy authorized equipment. And as to improper means, the issue there that was put forward was, well, they lied to us when they said that they wanted to buy our business. But that element fails, Your Honors, for the same reason that the promissory fraud claim fails. So the promissory fraud claim fails because, first, a critical element of any promissory fraud claim is you have to prove reasonable reliance. And the plaintiff on the witness stand admitted that he could not rely on the promises at issue, the promises to buy the business, because he well understood he could not rely on such promises. He had to have an agreement signed in writing. So reasonable reliance could not be proven, and the promissory fraud claim fails on that basis alone. But it also fails, Your Honors, because another critical element is you have to come forward with evidence showing that the promise to purchase the business was made without any intent to follow through with that promise, okay? The plaintiffs offered no material evidence sufficient to create an issue for the jury on that critical element, okay? So what's the Tennessee standard for that type of proof on intent? Tennessee Court of Appeals is clear on a couple things that matter here. First is that the failure to follow through with the promise, standing alone, that's not sufficient to create an issue of fact for the jury. The second point that this court has made, and they in fact made it in the Noblin case that's cited in the plaintiff's reply brief, is that circumstantial evidence that is susceptible to inferences of either innocent or fraudulent conduct is not enough to create an issue for the jury. You don't allow a jury to resolve competing inferences on that basis because the law, as made clear in the Noblin case, presumes good faith conduct when there are equally reasonable inferences that can be offered. The plaintiffs put forward no proof that satisfies those standards. The only evidence they offered was, one, that the promise to purchase the business wasn't followed through, and then two, they pointed to an email that an equipment share employee sent very early on in the negotiations over the purchase of authorized equipment, where he said, well, it looks like this equipment is too old for us to do anything with. Well, that doesn't alone by itself necessarily indicate that there had to be fraud. Instead, that can also support a very reasonable inference that that was that employee's personal opinion of the equipment early on in the negotiations when he was reviewing it. So for those reasons, Your Honor, there was more than enough arguments and basis for the court to enter directed verdict, whether on the failure of proof as to damages or the failure of proof as to liability. And Your Honors, as far as the bias and the recusal, I'll just say one point. The judge did not I was the attorney who conducted the voir dire. The judge did not nudge me into doing that or compel me to doing that. I stood up and said, I want to make this objection. We then had a discussion on the record, and I encouraged the court to read that as to how this objection should be made, and we ultimately did it through a voir dire. If the judge was so biased and dead set in ruling in our favor and in ruling against the appellees, she could have simply done that at that time without having a voir dire. She could have also done it pre-trial, but she didn't because she was not biased and there was no basis for recusal.
Thank you.
I think I want to address two issues with my 3 minutes. One, excuse me.
I also want you to address the issue of that opposing counsel has suggested that that we go further and look at causation here as well, and if this is a proper case to do that.
Sure. Let me hit that one first, Judge Stafford. I think that the short answer is no, because that is an issue that was not dealt with by the trial court. There's nothing for the court to review from the trial court. And
well,
remember,
I mean,
we're here.
All the evidence is there, isn't it?
All the evidence is there. It's a de novo standard.
And it's a matter of law whether or not causation was proven, isn't it?
Well, when we look at Rule 50, the standard obviously is that all inferences, all reasonable inferences, are to be drawn in favor of the plaintiff. And when we're talking about causation, what we're talking about is whether or not the breach of contract, the interference, or the promissory fraud actually caused damages. And let's just take one of those, Your Honor, so we can sort of have something tangible to talk about. Take promissory fraud. The evidence was that Mr. John Miller repeatedly told Mr. Mitchell, president of the plaintiff, that we had, quote, a done deal. That was reaffirmed in September during their text message exchanges, where after Mickey Mitchell went ahead and summarized the deal, Mr. Miller wrote back and said, we're good to go. And then on September the 30th of 2019, Mr. Mitchell drafted a very lengthy email, which is Exhibit 1 to the trial record, explaining in detail the transaction that had been agreed to, sent it to Mr. Miller and to his counsel, and Mr. Miller responded, some things are not as discussed, but, quote, pretty close. And so it was in reliance upon those different, both oral and written representations and promises that Mr. Miller had made that caused Mr. Mitchell not to seek to find another building to move his business to. See, that was the problem. This post-occupancy closing agreement required Mr. Mitchell and his business to leave Laverne in mid-November. And so Mr. Mitchell was led along by these false promises all the way through to October the 9th that they were going to go ahead and close a stock sale for $4.3 million. And it wasn't until October 9, just about 35 days before they were going to have to leave the building, that Mr. Miller sends this email saying the most we can offer is $2 million or $2.25 million. That's the causation, Your Honor. It was because it caused Mr. Mitchell to delay finding another place for his business. And because he couldn't find a place for his business in October, he had no choice but to liquidate. That's the causation. And that is something that the inferences, I think, prove in plaintiff's favor.
Did your client, I say your client, the owner, did your client respond as opposing counsel suggested during trial that he knew he couldn't rely on those promises of?
Not exactly. I think if I recall the quotation correctly, it had to do with until you have a signed agreement, can you rely on him? And Mr. Mitchell responded in words or in substance, no. But that's not obviously true in Tennessee law. I mean, if you actually make an oral promise that someone reasonably relies on, you have a cause of action for promissory fraud if you sustain damages caused by your reasonable reliance. The fact that something is not in writing as a matter of law does not destroy a promissory fraud claim. Plus, the question was framed in a way that allowed Mr. Mitchell, in his own mind, to understand that he had not just oral promises, he had written promises. The text message that I mentioned from September 17 and the September 30 email, Trial Exhibit 1, from September 30. Those were both sent, electronically signed, by Jonathan Miller. So even if we were to concede, which we do not, that a promissory fraud claim in Tennessee may only be based upon a written document, we have got written documents in the record that Mr. Mitchell was entitled to rely upon.
Thank you.
Thank you.
Thank you, counsel. We appreciate your briefing. We appreciate your argument. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time. You may be excused.